introduce us?
I will. Good morning, everyone. Thank you for being here with us this morning. We're glad to have the opportunity to present to you, even in an era where we can't do it in person, although I hope we're moving in that direction soon. My name is Ashlyn Linskog. I'm an attorney at Martin Pringle. We're excited to kick off this Chamber University series in partnership with the Chamber of El Dorado and Edward Jones, and really just start to offer some practical tips, advice, those types of things to the Chamber members and others, and really just start to create partnerships and connections with the fine people and business owners and professionals of El Dorado. So I'm going to let your experts for the day, Jeff and Zach, introduce themselves in a minute. I just wanted to come on and say good morning. And, Martin Pringle is really excited to be in El Dorado. We recently opened an office there. We're excited to get involved with the community. Martin Pringle has been around in Wichita, and when we've done work in El Dorado for years now, but I'm thrilled at the opportunity to be able to have an office there and to be a little bit closer when we need to be. So knowing those things, and without further ado, I will let Jeff talk a little bit about himself and Edward Jones, and then I'll let Zach introduce himself and we'll get started.
Fantastic, thank you so much. So I'm Jeff Christensen. I'm a local advisor here in El Dorado. I started with Edward Jones back in June of 2012, so I've been here for a little bit. I got licensed back in October of 2007, so if you remember that time frame, that is the absolute best time to start selling securities. Been in El Dorado for a little while, love Edward Jones and the firm it is. I like the way that the firm is client forward. They really care about the clients, and so partnering with the Chamber, just want to make sure that we're providing good resources for people, because I get a lot of questions about, do I need a will? Do I need a trust? If I have things set up, am I okay this way? If I have this beneficiary's name? And so I want to make sure we partner with the Chamber to provide a resource to the business community, but also it's great to have a firm like Martin Pringle helping out with this, and Zach has got a lot of experience as well. So Zach, I'll let you introduce yourself as well.
Yeah, thanks, Jeff. My name is Zach Wiggins. I'm a partner at Martin Pringle. I've been there for about 10 years now, and I specialize in estate planning and business law. So if you need somebody to go to court, that'd be Ashlyn. But if you need somebody to draft some contracts or help you with an estate plan, that's more my speed. So I get, similar to you, we get people with questions all the time about, do I need an estate plan? What is an estate plan? What are the options? And doing these kind of presentations, I think, can really help people to kind of understand why it could be important to them, even if they're not sure it is.
Yeah, thanks. So we're hoping that, so we have a couple people join. We're hoping that this is very interactive. If you just hear me talk and Zach talk, it's not going to be as entertaining as if you guys interact with us. So we're leaving your lines unmuted. So if you have a question, just chime in and say, hey, can you pause right there? I want more explanation on that or anything like that. So let's just start off like why you need an estate plan. And really estate planning is kind of a team approach. So when you think about the components of your estate plan, you're at the center of everything. You're dictating what it is that you want to have happen, but really partnering with whoever your financial advisor is, the attorney, that would be Zach in this case, and your CPA, to understand how those pieces move together to do what it is that you want them to do. So it really is a team approach to make sure that what you want to have happen actually happens after you are gone. So when I think through, there's some financial needs that we will typically have, either getting ready for retirement, making sure that they can live in retirement, and that retirement is actually what they want it to be. Education is a really important thing. Zach, I'm pretty sure that the law degree was not a cheap thing. So helping people out with those things is really important. Life throws us curveballs, and so making sure that we're planning for the unexpected things. And the last thing that we'll ever do is actually pass these things down to the people and organizations that we care about. And so We really want to focus in on that last one of making sure your estate and inheritance is actually set up the way you want it to be. So there's a couple of steps whenever you look at any kind of financial planning. We start off with where you're at today, what's in place, where do you want to be, can you even get there, how does that make it happen, and how do you stay on track? So the financial advisor and CPA typically kind of start with where you're at today. Where at that, where are they titled, how are they titled? That's where we start bringing in Zach and say, where do you want them to be? Whenever you're gone from here, what does that transition look like? Where do you want those things to go? Can it even happen? So if you want to give something to a certain individual, can that even happen? And if so, how do we make it happen? And then, Zach, I think you'd probably be on board with this one, making sure we stay on track. Estate plans are not static. Things change over time. So making sure that that estate plan is still in place and still says what you want it to say 5 years down the road, because you never know what's going to happen there. So we'll pause and ask anybody have questions about that.
I don't have any questions, but I do get quite a few examples of estate plans not staying static. There's a number of reasons for that. You're a couple that did an estate plan with a little bit of assets to say who they go. That's a big difference than a couple that then has a kid and needs to determine, who's going to take care of their kid, which is also different than when your kid gets to an age where they don't need it. And we see examples all the time where somebody has a will. Probably the best example is, I believe my parents' will, they're working on this, but I think my parents' will still says who's going to take care of me if something happens to them. So trying to get that corrected, but that's an example of, maybe the things that you had in there umpteen years ago don't quite make sense anymore.
Yeah, exactly. My own personal story, my mom had quadruple bypass a couple of years ago, and I asked them about their power of attorneys and wills, and Dad said, yeah, our will was done, but it was done like 30 years ago. I said, you're still going to live with your uncle if something happens to us. And I said, fantastic. So I called my uncle up and said, congratulations, if something happens to Mom and Dad, I'm moving in. So I'm married now with kids, so there's a little bit more to that puzzle than it was before. So I think sharing stories is a great way to help give illustrations about what suits different things. And so we'll kind of do that in this format here. So when it comes to your estate, everybody has an estate plan, whether they have something written down or not. So whether you have a will or a trust or you haven't done anything, you have an estate plan of some kind. And so the big question is does the plan really reflect what you want to have happen? And that's why you're at the center of those conversations. So we'll start with the first scenario. We don't have an estate plan, and we don't need an estate plan. Zach, I'll let you kind of tackle this one a little bit.
Yeah, we get that question quite a bit from people. Do I really need one? I don't have very many assets. All I have is a house. It's transfer on death, or my kids are grown up, or whatever it is. And there are probably situations where there is somebody that doesn't really have to have an estate plan. But as a general rule, there is a benefit to having one for almost everyone. And it could be something as early stage as, if you have a child, if something happens to you and your spouse, then someone's going to have to take care of your kid or kids. And if you don't choose in your estate planning documents who that's going to be, then the courts are going to choose for you, or the state is going to choose for you. And that's not a great situation to be in. Even in a place where there's lots of people that want to take care of your kids, that can still be an issue because more than one person wants to have control, and you don't get a say in it if you don't put anything in. So there's that aspect of it. As far as finances, obviously, the more assets you have, probably the more relevant and complicated it can become, because there's lots of different things you can do as far as charitable contributions, or splitting it this way or that way, or planning to avoid taxes and whatnot. But even if you don't have a lot of assets, it can still be very important because, like you said, everybody has an estate plan, whether they do it themselves or not. And that's because of something called intestate succession, where in Topeka and our Kansas statutes, they have basically said, if you don't do it, then this is how it's going to go. It's going to be split this way and this way. And it's not very often that that plan is consistent with what you wanted. And I'd say a good example of that is if you're married with a kid and you pass away, then your estate is going to go half to your spouse and half to your kid. Well, if your kid's 8, maybe you would rather have your spouse have all that money, but that's just how it's going to go if you don't do any planning. And even on the other side of the spectrum, from all the planning of asset protection and all that stuff, if you don't have very many assets, then the other side of that is you could be doing Medicaid planning. So you can be planning ahead for, I don't need it right now, but down the road, I might need some state benefits. And if you plan ahead, you can still pass your assets to your family. If you don't plan ahead, then, the state's going to take it all. So really both ends of the spectrum, all the way from I have hardly anything to I have lots. There are different estate plans, but there's usually a reason to have one that is better than letting the state choose for you.
The state doesn't always do what I want it to do.
They rarely do what you want to do.
Right. So having something written down is better than not having anything at all. It's kind of what you're getting at, right? So, so let's talk through kind of the second scenario of it won't happen to us, right? So talk to me about, like, you have somebody who comes in the office and says, my kids are great, I'll never argue about things, or we're healthy and we don't need to worry about Medicaid or Medicare, Medicaid planning or anything like that. Tell me a little bit more about why that attitude is maybe not something you want to plan for.
Well, like I mentioned when I started, I don't do a lot of the litigation side of it, but I can pretty much promise you that every dispute within that has started with, it won't happen to us. And they didn't do anything, they didn't plan it out, and then it ended up in a situation where it did happen to them. Pretty much every time there's something that comes off, they didn't plan for it. A lot of times they started with, it won't happen to us, we don't need to worry about that. But it's sad, and you're probably right. I only hear about the ones that do go wrong. So the ones that go perfectly well, I generally don't hear a lot about those. So, it is skewed a little bit in that, the ones that we tend to come across are the ones that have gone wrong. But it's amazing how much a little money can sometimes really affect relationships. If there's a disagreement about what should happen to it or how it should go, it can get messy, and it's sad when it does, because it's generally would have been really easy to avoid any of those issues if you spent a little bit of time putting a plan together. Then most of those issues could have been avoided.
Yeah, and it's amazing that whenever I think about just my own experiences with clients and families and things like that, we had there's a client who had a trust who got set up and things like that. The thing that was the point of contention for the family was the Christmas candle that sat on the table at Christmas time, right? That's what Christmas was, the whole family, and that's what the kids fought about and argued over. It's kind of strange because it's not the dollar sign. Sometimes it's something like that, where it's a significant thing to the family. And I think that's where it's important for the financial advisor and yourself and the CPA to really kind of get involved and know the dynamics of the family, what's important to them, outside of just the who gets what, right? So
yeah, I think I've seen countless examples of that, where there's a family dispute over something that you wouldn't think would be worth it. I've seen us have to travel from Wichita. We've gone down to Wellington to have a hearing with multiple attorneys involved over rusted out old Bronco, like buried in the ground, that couldn't have been worth more than like $500. And there were 4 attorneys there fighting over it, and every one of us is telling our client, like, we should not be doing this. This is not you're going to spend more money arguing about this than that thing is worth. And sometimes that doesn't matter to people. So,
yeah. So it's a little off script because I think it kind of falls into this, so it won't happen to us. But talk a little about the cost of estate planning, the cost of doing it proactively, or the cost of someone like Ashlyn coming in and litigating it.
Yeah. Well, they're substantially different. Obviously it depends on what you're going to do and how complex it is and what kind of planning you're doing, but rough ballpark, a relatively straightforward estate plan, probably going to be somewhere between $750 and $1,500, somewhere in that general range, maybe a little bit higher than that if there's some more assets or some more complexity to it. But it's probably generally the ballpark that you're looking at. If there's a dispute, you're looking at tens of thousands of dollars very quickly. It's amazing how fast probate litigation can add up. So yeah, it's way cheaper to spend a little bit in advance than to do that on the backside. And again, vast majority of the time that bad stuff doesn't happen, but when it does, it tends to be quite an event.
It's not cheap.
Yeah,
because people are pretty entrenched in whatever views they have, and they want to kind of hold to that, which is why we're fighting about it. So
the other side of the won't happen to us it's not just the the family disputes that you don't expect to come. It's it's accidents that happen, unexpected deaths. Unexpected people don't always die in the order that you expect them to, and there's no way to plan for that. You never know what's going to happen. And so for the people that have done their estate plan, that's one of the things I say, it gives them some peace of mind that they know their plans in place. If something that is very unlikely to happen did happen, we know that we've done what we need to do.
Sure. Well, and that whole idea of it won't happen to us, and the fact that you have experience in dealing with these things and kind of help say, hey, here's some other things that we want to plan for in addition to what we're talking about, really kind of lends to the experience that you bring to the table for those situations. Am I right?
Yeah.
So
yeah, I do a fair amount of real estate probate kind of matters where somebody passes away, family wants to go sell this house, and nothing was ever done to transfer the title, and now it's trying to figure it out. There might be liens on it, there might be other issues that it would have been a very simple process with a little bit of planning, but then it becomes more difficult, longer process without that, and that happens all the time.
Sure. Yeah, it happens pretty frequently, which is why you're in business, right? So so let's move on to the second or the third one. We already have a plan, so we're good. Talk a little about that.
Yeah, it's kind of like what I was saying at the beginning, example, it sounds like both of us have had an example of we may be in the care of certain people if something happens to our parents. So that's something that changes. The amount of assets you have change, your situation changes as far as, are you going to need Medicaid or are you not going to need Medicaid? That's something that can easily change over time. Who you want to take care of your kids can change over time. And, as you start getting a little bit higher in asset values, the tax law changes. Part. So it's constantly a moving target. And sometimes, that is something that if you have enough assets that it matters, then you really need to stay on top of that, or you could end up with a really large bill that you weren't expecting. And most people would rather it go to their family than to the IRS.
And I think it's also important to know that yours is an evolving business as well on your side. So trusts that were done 20 years ago look very different than trust planning that's done now. Can you talk a little about that? Because a lot of people will say, hey, I have a trust and I'm good. And I say, when did you do the trust? And they'll go 1995. I go, have we looked at it since then? They go, well, no, I have a trust. Why do I need to look at that?
Yeah, trusts are, I mean, both of them are interesting because, I mean, there are these disputes. So there's laws that change. There's case law that changes. You know, some provisions that you put in before that make complete sense might not make sense now. A good example of that is it's a tax law issue. The estate tax, there used to be a Kansas estate tax, so an inheritance tax paid to the Kansas state. That's gone. So you don't have to plan for that anymore because it doesn't exist. So if you did one before 2009, there's a good chance that there's provisions in there meant to protect you from Kansas estate tax when there is no Kansas estate tax. So, you know, that's the kind of thing that can change. And, you know, especially with trust, one of the big things is titling assets and making sure your assets are in the name of the trust. Because if you don't put them in the name of the trust, then the trust doesn't really do anything. So if you did a trust 20 years ago, 20 years from now, you should probably go through and check the titles and make sure your beneficiary designations are up to date and make sure your real estate titles are in the right name, and, you know, just kind of do a little bit of an audit of where you are. And, you know, your financial planner can obviously help you a lot with that part of it. And if any changes are needed, you know, your attorney can make those adjustments for you.
Sure, absolutely. So the audience has been fairly quiet throughout this whole thing. Do you guys have any questions for us at all? Want to make sure that this is interactive and we're answering any questions that you guys might have too. So if you guys want to unmute yourself, you guys can unmute yourself. So,
you know, I guess, you know, we were talking about trust there. A lot of times we get the question of what is a trust? And I think, you know, at least let's cursory overview of the difference between a will and a trust might be useful for a lot of people.
Absolutely.
And I'm sure you come across plans that have both of them. I tend to prefer the trust planning, but, you know, a will is a perfectly acceptable way to do it. So the difference is a will, it's called your last will and testament. It's basically you saying, hey, when I pass away, this is how I want my property to pass. This is how I want to take care of my kids. This is who I want to get that Christmas candle. This is who I want to have that. This is who I want to have that Bronco go to. That's your will. The problem with the will, not necessarily a problem, it's just a fact that a will doesn't actually do anything until you take it to court. So it's called probate. And in order for a will to become effective, you have to go and probate it, which means you have to go through the court. You have to tell the court, hey, court, this is so-and-so's will. They passed away. Please admit this will into probate. And then you have to go through a pretty strict process over a period of, you know, probably about 6 months at least, if everything goes smoothly, to where you try to find all of the decedent's creditors, make sure everybody's getting paid, make sure if there's any money left that it's going to the right people. It's a very public proceeding in that everything you do is in the public record. I've done some, in the real estate work I've done, I've, you know, looked through a lot of those records and I can see pretty much what happened to everyone. And if there's an issue, I can see it. And some people don't want that to necessarily be in the public record. So, but it's not bad. I mean, it's something that a will would be perfectly fine. The other problem with a will is that you have a certain period of time for you to probate it. So if you wait more than 6 months, you're out of luck. The will basically becomes null and void with some very, very small exceptions. But so you have a pretty strict deadline on what you're going to do.
We do have one question
Yes.
From the audience. Like, are there issues with wills not showing up or being found to submit to probate court?
Yeah, there can be. There's not really there's no public place that you file a will when you get it. You keep it in your safe, your vault, your house, whatever. And if you don't tell anybody where it is, sometimes they get lost. Or if you lose it, chances of somebody else finding it, especially within the required amount of time, can be a difficult thing to do. But even that's not usually a good enough excuse for it to get admitted outside of that 6 months. Usually it takes somebody having the will, knowing they have the will, and essentially hiding it from the court in order to avoid that. But yeah, that is an issue. And we always recommend that, you know, people keep it all in a safe place. Make sure you tell somebody what that safe place is. Keep those papers laying around. You know, the attorney that drafted his contact information will be on there, so you can reach out to them. Flip side of that is, another problem is if you have a will and you change your will, we always recommend destroying the old one, because that could be an issue too. What if you find one and it turns out it's not the most recent one? So we're usually pretty careful of, if you have an old one, destroy it, keep your new one. Okay, what's that?
No, absolutely. That's a good thing. So we have, one of the things that we do whenever we're talking and working with clients is whenever we know that they have wills, power of attorney, trust, whatever it is they have for their document, ask them where it's at, and make a note of that in their file, because we literally have a client who it's in the red shoebox in the basement underneath the stairs. That's where our stuff is at, and we have a note of that, so that way whenever that day comes and they're not here, and the kids are looking for it, I can say, here's where things are at. So notifying somebody is incredibly about that as well. So people need to be able to find it. So great question. Thanks for asking. So let's move on. Go ahead.
So that's a will. A trust is something that basically does the same thing. It gets property from you to who you want it to go to, but you don't have to go to court to do it. So it's basically a contractual agreement where you say, hey, I agree with my trustee, which in most cases when you're doing a trust is yourself. So I agree with myself that I'm going to do the following things with this property. If something happens to you, another person becomes your trustee and they have to do the same thing with the property, which is hold it for your kids or give it to your beneficiaries or whatever. But the nice thing about a trust is it's private, and you don't have to go to court over it. So it can make the administration of it quite a bit easier.
Right. So the less time you have to involve courts on things, sometimes the smoother things go.
Yeah.
So let's talk about some common objectives of estate planning. Just, you know, what should it do? So talk through a little bit about asset transfer, incapacity, guardian for minors and dependents, and that dependent may not be a minor, charitable intent, tax control. Talk a little about how having a plan in place helps you out with these things.
Yeah, so asset transfers, you know, the main one usually is, how do I get it to the people that I want it to go to? Like I mentioned earlier, if you don't do any estate planning, you pass away. If you're married with a kid, your kid is going to get half of your property, including half of your house, half of any other real estate you own. And generally having, you know, an 8-year-old owning real estate is not very conducive to putting that real estate to use. And it actually becomes such a problem that in order to do anything with the real estate, the parent can't even sign on behalf of the child usually. So you actually have to go get a guardian, or in this case, a conservatorship appointed. So you're basically having to have the parent appointed as a conservator for the child in order to do anything with the real estate. Obviously, that's not something that people really want to be in a position of doing.
Yeah. So the other thing too is if it's a grown child and that child's married, all of a sudden you have to enter that spouse into the equation too, because Kansas is a marital property state. Yeah. So it can get messy really quick.
Yes, it can. The other thing with the other asset transfer part with children is, if you're married with children, if you pass away, say you have, I don't know, a couple $100,000 or whatever it is. Well, again, you probably don't want a couple $100,000 going to an 8-year-old or whatever. So there are some legal protections in place. If you don't have a plan, they can essentially be held as a uniform transfer to minor, which is basically it's going to be held in account for the minor until they turn 18. Once they turn 18, that money is theirs and they can do whatever they want with it. A better way to handle that is if you say, hey, if we get in that position, then I want that money to be held in trust for the kids so that the trustee will have the ability to use that money for my kids, for their health, their education, their maintenance, and their support. And then, when they turn a certain age, then we can go ahead and start giving them more of it. Maybe when they're 25, they can have the money, or they can have half of it when they're 25 and the rest of it when they're 30. Something like that. It's theirs.
Right. Talk a little about incapacity protection. So Alzheimer's runs in my family. So at some point in time, chances are I'll start getting very forgetful and developing it's part of my family's history, right? So at some point in time, I might be incapacitated. So talk about how you help protect people and with estate planning, with that kind of stuff.
Yeah, good question. There's really two ways that we do that. One is that we do powers of attorney. So your power of attorney is basically, I'm saying that if I'm incapacitated, if I can't make certain financial or healthcare decisions on my own, this is the person I want to have make that decision. I want my wife to make that decision for me. If my wife can't do it, then I want, my parents to make those decisions. And it lays it out as to who gets to make those decisions. If you don't have one of those in place, then eventually somebody's going to be able to make the decision for you, but it becomes a lot messier and a lot more difficult. And sometimes those decisions need to be made relatively quickly.
Right.
So if you have the powers of attorney in place, you're protected in that your financials can be taken care of, your health can be taken care of. But if you can also say, if for any reason I become, so incapacitated that the powers of attorney aren't enough, then I might have to have somebody appointed for me as a guardian or a conservator. The difference between those is a guardian basically takes care of your well-being, makes your daily life decisions of where you go, what you do, kind of thing. Your conservator takes care of your financial aspects. So two different hats, but a lot of times they'll be the same person, but not always. And you can put in some of your estate planning documents that if something happens that I have to have somebody appointed for me, this is who I want it to be. That way your family members aren't having to have disagreements about who it should be. Should it be, if your parents are divorced, should it be your mom or your dad, or even if they're not, you want them to be both be in that role, or someone else, or do you want different people do you want some kind of financial institution to handle your finances and have some person handle your healthcare? Those are decisions you can make in your estate plan. But if you don't make them, then someone else will make them for you.
Yeah. Anybody have any questions on the other items here? I want to make sure we're also sensitive to people's time. Cameo, I think we have an hour for this whole thing, right?
Yes.
Okay, so we can touch on the guardian for minor dependents. I know for myself, we have a child who's on disability because of his schizophrenia. And so making sure he's cared for and advocated for is a big thing. He's not a minor anymore, but part of our estate plan deals with making sure he's cared for if something happens to us. But we don't want him in control of those assets, because there's times that he doesn't make great decisions because of his schizophrenia, right? So there's all kinds of things when we're thinking about guardians for minors or dependents that we want to make sure you're taking into consideration as well. Because just because they're grown out of the house doesn't mean they're not dependents anymore sometimes. So
absolutely. Governmental benefits is another big part of that, for adult children that have access to some kind of Social Security or disability or Medicaid or some other type of government assistance. If you give the money outright to them, there's a good chance that they're going to lose that. Even if you're giving them a relatively small amount that they're going to burn through in no time, just paying for their care. So, you can set up certain trusts that avoid that, so that, the money you give them can be used for, kind of supplemental stuff,
right.
Like,
talk a little about charitable intent, because giving is incredible. So a lot of times people are very passionate about certain organizations and certain things. So talk a little about charitable intent and how that plays into estate planning.
Yeah, a lot of people have, either a church or a certain charity that they're very passionate about, and they want to, give a small or large percentage of their estate to a charity or a church or whoever they want to give it to that is kind of with a charitable intent. And if you don't do any planning, then that's not going to happen. It can be a very useful tool as you build your asset value and your wealth. There are certain assets, as of today, most assets that go to your kids are not going to be taxed. They're not going to pay tax on it. They get a step up in basis. So if they take real estate or whatever and sell it, they probably won't have to pay taxes on it. But there are some assets like deferred retirement plans where no matter what you do, if it goes to someone, it's getting taxed, unless that someone that it's going to is a charity. So if you have the kind of assets and retirement plan where it makes sense, that could be a way where you could give some of the taxable assets to a charity who doesn't have to pay taxes, rather than giving it to, your family that would have to pay taxes. So you can be charitable, and it can be a lot more impactful. If you give $100,000 as taxable to somebody, it's worth whatever, 65,000, whatever that is. If you give it to a charity, it's worth 100. So as you start getting into that, there's some good tax control type planning for it that you can do. And even if it's not for that purpose, it could just be, I want to give 10% of my estate to my church, or I want to give it to WSU and create a scholarship. Things like that are things you can certainly do.
Yeah, it's important to know. So like we talked about at the beginning, where like that person's at the center of that relationship, but having the financial advisor and the CPA kind of involved as well. Because a lot of times people just say, well, I want, half my money to go here and half to go here. So they set up, 50-50 beneficiaries on stuff. Whereas sometimes it might make sense to allocate certain assets to certain organizations or people, like you said. So have that understanding of where the assets are makes a big difference whenever you're talking through that estate planning piece. Talk a little bit more about tax control, because obviously whenever we have an administration change, there's always tax issues that come up as well. So talk a little about how that you can actually help control some of the tax issues that people might face through the estate planning process.
Yeah, tax is one that I think a lot of people are very passionate about when it comes to the estate tax. A lot of people are surprised when they find out what exactly the estate tax is and who is subject to it. But like you said, with administrative changes, then that goalpost can change pretty significantly. So when Trump took office, the exemption amount was $5 million, which basically meant you could pass $5 million of assets to your children or whoever you wanted without paying any tax. If you're married, you can do 10 million. During the Trump administration, that went up to it's now $11.7 million per person, or $23.4 million per couple. So very, very, very few people are actually impacted by it at the current levels. The new administration might take that back to 5 million, slightly less of a risk of it going back to like 3.5 million, but it's still a lot of money that most people don't have to worry about. But there certainly are people that have to worry about it, and especially if you're kind of in that area between the 5 and the 10, or somewhere in that range. Now is a really good time to talk about some pre-planning you can do to pass some assets now, or take advantage of the currently elevated amount, things like that. The other side of that is income tax control. And, as I said earlier, if you pass real estate to a beneficiary, they can then sell it and not have to pay any taxes, which is a great system for passing assets without having to worry about your beneficiaries having to pay those taxes. Although that is another thing that this administration has talked about potentially doing away with, is that it's called the step up in basis. So again, that's just the moving target. The goalpost changes, taxes change, plans change. And that's why doing something from 20 years ago might not have any relevance to today.
The estate limits 20 years ago they were well below, there was below $1 million at one point in time. So those goalposts, like you said, kind of change and move as things go along. So When we talk about estate planning and kind of the goals for it, there's kind of three main goals that we think about. So planning for the expected, planning for the expected, preparing for the unexpected, and making sure that everything's positioned for both, right? And we've talked a little bit about that with, the incapacity planning and things like that, and making sure that there's curveballs that life will throw at you sometimes that we want to make sure we're ready for. And there's all the things that we want to have happen that we want to make sure we're planning for as well. So it's making sure that whatever plan you have in place, you rely on people that have been through this, that have done these kind of things, have seen the hurdles and the roadblocks that come around from different stuff, to make sure that whatever plan you have actually positions you for both of those things. So, so a lot of whenever we think about planning the unexpected, a lot of it just comes from making sure that you have a really good understanding of your current situation. So when we think about that team approach, we had lunch with a very good friend a couple weeks ago, and she doesn't work with me because she's going through a divorce and things like that. And I don't, it kind of feels like he's being nosy. And I said, he needs to, the better he understands your situation, or she understands your situation, the better advice they can give. So when you think about planning for the unexpected, making sure that people that you have that you're trusting to make sure that you're partnering with on this kind of stuff know where things are at, know what your situation looks like. They understand the family dynamics as well, right? So that's a really important thing. So sometimes it can get a little messy with these kind of conversations, but it can dig up a little bit. But it's important to make sure that when we're thinking about planning, that these things, because it impacts the way that we structure stuff, right? And like we said, like life changes too. If we have a child who's making great decisions at one point in time, but 10 years down the road had kind of fallen on hard times and is not making great decisions, your estate plan might need to reflect that. And your plans and your priorities and objectives might change as well. So reviewing those things on a regular basis is also really important too. So
the plan for the expected part is also can make it easier to accomplish your estate plan, because as you might have noticed through this presentation, a lot of estate planning is planning for the unexpected, the next part of it. And, a lot of things can go wrong, but they usually don't. They usually don't go wrong, but this is all planning for something that you don't expect to happen and probably never will. But, some of the conversations and thoughts and, things you have to think about in doing your estate plan is, not exactly all sun and rainbows, because you're planning for problems that can occur. So keeping in mind that, this is how we want everything to go. This is how we think everything will go. Everything's going to do great. And if you have the plan in place, you know it's going to go a lot of that direction, can help give people some peace of mind. The other aspect of it we haven't really touched on too much is, businesses, family businesses are a big issue, and I know they are in El Dorado and throughout the area. But that's one big thing of, you started a company from the ground up, you own a company, and now something happens to you. What's going to happen to your company? You need to have some kind of succession plan in place, and it's not necessarily exactly the same as your estate plan, but it's a big part of it. And that can involve, buy-sell agreements between people. It can involve appointing a successor to be in charge after you're done. But that's, for a lot of people, that's their big thing is, I want to take care of my children and I want to know that, my business is going to keep going after I'm done. So I think that's another part that you want to make sure you're thinking about and taking care of, and talking to your all three of those, really, your financial advisor, your CPA, and your attorney need to be involved in that side of it.
Yeah, it's definitely a team approach to making sure that those kind of things are taken care of. So make sure we're progressing along. So unexpected, like life events and stuff like that happen. Our beneficiaries have stuff change, right? So you could have somebody get married, die, you could have divorces, you could have births, all kinds of different things can happen along those lines. Let me silence that real quick. Sorry. All kinds of things can happen. We've talked about the government changes in tax laws, regulations. Those kind of things will impact that kind of stuff. The last one here is incorrect implementation of the strategy. That's one that I see, and Zach, you probably see more than anything else. So you do all this work to go through all this stuff of here's everything I have, here's what I want to have happen with these things. And typically they walk away from you with a nice big binder, right? And then the biggest thing is that it just doesn't get implemented right. Talk a little bit about that and the pitfalls of it not getting implemented right. A lot of times people think that, well, I've got to trust, so everything's okay.
Yeah, I mean, that's one thing with a trust. I mean, it's kind of hard to conceptualize what exactly a trust is, but I think the easiest way is to say that a trust is essentially creating this bucket of assets. I'm going to put all my assets in the bucket, and then I'm going to agree with someone that this is what's going to happen to all of the assets that are in the bucket. You know, with a standard one, it's while I'm alive, those assets can be used for me in any way, shape, form I want to use them. I can amend it, I can revoke it, I can change my beneficiaries, I can give it away, I can go to Vegas and put it all in black, whatever I want to do, I can do it. And when I pass away, whoever the successor trustee is going to take that bucket of assets and they're going to hold them or distribute them or give them away or do whatever it is that that contract says is going to happen. Well, the incorrect implementation that occurs is, what if I don't fill that bucket with anything? So when you create a trust, you have to actually transfer your assets into that bucket that's going to be governed by the trust. So my house, my real estate, my business assets, my oil and gas interests, my personal property to some lesser extent needs to be put into that bucket. So we create a lot of documents. We deed property from you individually into your name as trustee of your trust. We change your business ownership from your name to the name of your trust, or we put it as a transfer on death into the name of your trust, something along those lines. Or, you know, we do assignments, we do declarations that I declare that I'm now holding this in trust. Vehicles can be one where we usually say if you just have, you know, one car, don't really worry about going to the DMV and retitling it. But if you buy a new car, you know, you can put it in the name of the trust. Things like that, I think, can need to be done, and they don't always happen. Beneficiary designations is another big one. People will say, well, I have my kids named as beneficiaries of my retirement account, so I'm good. And it's like, well, you're good as long as, you know, as long as everybody dies in the correct order, the expected order, then it works. But it becomes problematic if, you know, anybody predeceases you or anything like that. It can get messy. And sometimes the easiest way is to have that flow into your trust account. That way it's in that bucket and everything is treated the same. So we always say, you know, one of the most useless estate planning tools is a completely unfunded trust, because until it's funded, it doesn't do anything. Right. Now we do plan for that possibility. So when we do a trust, we also give you a will, and that will is called a pour over will. And all the pour over will says is, hey, I was planning on putting everything that I own into this bucket. If I missed anything or if I missed everything, pour it into the trust, and then the trust will govern that. So there's a backup plan, but that backup plan requires you to go to probate court, which is the whole point of the trust, was to avoid probate court. So it doesn't do much if you're having to use the will to get to it. So right. There's a backup plan that'll protect you, but we don't want to use that.
Yeah, we don't like having to go to plan B. Let's stick with plan A, right? So anybody have any questions? We'll kind of stop here. We've got about 10 minutes left. So does anybody have any questions they have burning questions on at all? You can feel free to either unmute yourself, or if you'd like to just put in chat, that's perfectly fine as well. So I want to make sure this is really valuable to you guys. Kind of give it a second, maybe. Okay, so we'll move on. Positioning for both, we've talked about this a little bit as well already, but guidance on making sure how to allocate your investments, making sure that your portfolio, your assets, is all positioned for both the stuff that you do expect to have happen and also the unexpected. Medicaid is a fantastic tool, but sometimes we don't want to use Medicaid. We'd rather use, some type of long-term care to make sure things are taken care of. We talked about businesses. I might have a child who wants to come in and take over my business and assume responsibility for the business, but does that leave the other two kids out of the picture, right? And do I really want to do that? And sometimes the answer is, yes, they've been working the ranch all this time and they deserve it. And sometimes the answer is no, I'd like to make sure everybody kind of gets treated equally. So it's also understanding what you want to have happen with these things to make sure that it lines up with that. So
I've seen some people refer to that as the fair versus equal question.
Right.
Right. You have one or two kids involved in the family business doing all of it. You pass away, you split that business 4 ways between all your kids, including the ones that haven't had anything to do with it. It's equal, but is it fair? And that's a discussion that you should be having with your team as to how you want to do that. There might be other ways that you can adjust it and give the ones not involved in the business something else instead of the business or whatever, or life insurance or something.
Right. And there's all kinds of ways that we can make that work. It's just a matter of making sure that we have a good understanding of what it is that you want to have happen. And so there's when you go and have those conversations about this with myself or with Zach or whoever, we're going to ask you a lot of questions, and they're kind of uncomfortable questions. And it takes a while to make sure that we have a really good understanding of what it is that you want to accomplish and why, so that everything that we do on the backside of things actually matches up with that. So, yeah.
That is one other point. There's a lot of questions. There are hard discussions. You might waver. Useless than an unfunded trust is an unsigned estate plan.
Right.
And the number of times we get an estate plan right to the finish line, and it doesn't get signed because they are uncomfortable questions. It's not fun to think about. What happens when I pass away? What happens if one of my children predeceased me? Whatever. It's not fun to think about, and it's not fun to make those final decisions. So that's where you get into, do the best you can for now. Get something in place that's better than nothing.
Right.
And then if you change your mind in a year, it's not that hard to change them.
No. It is easy to go back and ratify things and get it all taken care of. So where you can hammer something out and go, okay, this is where we really stand on this, or we change our mind on stuff. Doing amendments to ratifying things is really not that difficult to do. So, yeah. So again, the team approach is really, really important to look at. Making sure that you're the center of that financial plan, that estate plan, but really working with your financial advisor, your attorney, and your CPA to make sure that plan all gets put in place and is set up the right way. But again, you're the center of that financial plan. It's your estate plan. It's all about you. The importance of review, we've kind of talked about this as well, just making sure that everything still stays current. So we talked a little bit before this, but sometimes power of attorney, something similar to power of attorney, a lot of times it's very difficult to get power of attorney since the power of attorney laws have changed dramatically over the years. A 20-year-old power of attorney it may not cut it anymore. So making sure that the documents are current and still applicable. Making sure that you review life changes. If a kid has gotten married and all of a sudden we don't want that going to, or they're going through a divorce and all of a sudden we don't want those assets going to the ex-spouse, making sure that your trust or your estate plan reflects that. Illnesses. I mean, there's clients that we've had that have gotten illnesses. Their children have gotten ill later on in life, and all of a sudden they're on disability. And so, but their trust, their estate plan that's originally set up didn't reflect that. So making sure that everything that's in your documents supports what's actually happening in life right now. So getting that great big book out and dusting it off and reading through all the heretofores and theretowits that Zach charges for.
If you made it easy to read, you wouldn't need us.
There you go. Should not be written in Old English, right? So, but making sure that you read through it and go, okay, does it still say what it needs to say? And if you have questions about it, reaching out to the attorney and going, hey, here's where our life is at, and do we need to make some changes here? And if so, they'll say, yeah, we need to make an amendment to this or whatever. So, Zach, any other questions on the review process? Do you have a time frame that you recommend people review it every now and then?
Oh, I mean, I guess it depends on where you are in, kind of in your life situation. The closer you get, or the more in depth it is, the more you probably need to change it. If you look at it every couple years or so, that's probably a good idea. Certainly, I'd say every 5 years or less. But
Kind of what we do. We tell people, like, once we know you have it, we're going to make sure we pull it out every 5 years and review it. And maybe go visit the attorney or do a quick phone call with them and just say, hey, does this still say what we need it to say? And that way things still stay current, they still do what you want them to do. Because again, the fight on the other side of things is a lot more expensive than the conversation is. So questions for us at all? We're wrapping up. Last minute questions for us. And you can unmute yourself or you can go into chat and do it either way. I'm not getting anything, so.
Awesome. Well, thank you, Jeff and Zach, for hosting and being the presenting sponsors for this month's Chamber University. So thank you guys both so much for that great information.
Yeah, absolutely.
If you have questions, feel free to reach out to myself. Reach out to Zach. I can't believe I can't talk. Reach out to Zach as well. I'm happy to answer questions. I'm happy to go through things. If you have questions on things, happy to go through that with people. I'm sure Zach is as well. So.
Awesome.
Amy, I don't have anything else. No.
Okay, well, that sounds great, guys. I think we'll just wrap this up. And for those that missed it, this will be on our new website hopefully soon. So if you have any questions, reach out to me and I can get you the information for both Zach and Jeff.
Yep.
Okay.
There is a final disclosure at the very end saying, hey, I'm not a legal person. That's Zach. So, not providing
legal person, but this wasn't individual legal advice.
That's right. So thank you guys. Appreciate it.
Thanks, everyone.